Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you. Hi, welcome to 3Bs on the Law. My name is Trisha Barita, and I'm, of course, the Texas B, and I'm here with Camille, the California B. And we're missing Susan today, of course, our Midwest B, but we hope she's having a great day off wherever she is. Today, Camille and I are excited to talk about an interesting topic. It's been in the news recently with Amazon. We'll start out with just sort of discussing the general idea that when people are thinking about going and bringing their claims potentially into court or a dispute with another company or a dispute with an employee, they often think about what would the jury think, how would the jury react to this claim, and sometimes these claims never make it before a jury. And one of the occasions where that would happen would be if there was an arbitration clause in place between the parties, resulting in the claims to come before an arbitrator or a panel of arbitrators. So Camille and I wanted to discuss sort of what is arbitration, why is it different than a jury trial, some of the pros and cons, and then a little bit about this Amazon case that's been in the news. So Camille, just starting off, what is arbitration? Let's talk about that.
So arbitration, unlike a jury trial where you're in your courtroom, actually usually takes place in a conference room. And it takes place at the convenience of the parties. So you could have it in the evenings, you can have it in the morning, you can work on it during lunch. But the parties present their case a little bit less formally than you would if you were in court to either a single arbitrator or to a panel of arbitrators. And there's a lot of pros and cons to doing that. The biggest pro I think that people like is that it's often resolved much more quickly than a lawsuit in court. And it's also confidential usually. And so you don't have a potentially dirty laundry of the company or of the parties aired in open court, which can be desirable to some people.
That's right. And so, the way arbitration can kind of come about is either the parties have agreed in some sort of contractual agreement prior to working together or with an employee and an employer, or, at some point during the working process, or it could be that there's a dispute and the parties just decide because, like, for instance, the confidential nature of it, or they just think it may be the best route for them that both parties want to pursue this sort of other type of way to resolve issues between the two parties. And it can be very successful. I've been involved with them and they've been, at least I've enjoyed that they've been successful. I don't know about the other side, but they can also be frustrating because there's no appeal, which it does make it shorter because it will be resolved one way or another. It's generally binding, right?
Right. And one of the issues also that can arise is because you have simplified rules of evidence, you can be confronted with affidavits and potentially witnesses that you haven't had an opportunity to review and cross-examine as you would if the case were in litigation.
That's right. And then you look at that issue also, Camille, when you've got an arbitrator, they're both making the fact, determining the fact issues and also the legal issues, right? So when you're in a court, it depends on kind of what it is the issue is. But if you're generally bringing something in front of a jury trial, there's usually some type of fact issue that the jury gets to decide. For instance, in a basic idea of this, right, in a car wreck case, the jury would be the ones to decide whether or not it was a red light, green light, if there's a dispute between that. And whereas the judge may be deciding the issues of law, for instance, what type of law would apply to the jury charge that would be presented to the jury, whereas the arbitrator gets both those jobs.
Right. And so you really have to make sure when you're choosing an arbitrator that you choose someone that you hopefully believe will be objective.
Yeah, so there's a lot of vetting, I think, usually in the arbitration picking process. Everybody wants the person they think, is going to, side with them in their case or give them the more favorable ruling. And usually both parties want someone with some knowledge about whatever it is the subject of the case is. So if it's a personal injury case or an employment law case, you're not going to be wanting to pick, someone that has usually no legal experience or background in that area of law.
Right. And that is actually an advantage of arbitration, is that you are going to get someone who has firsthand knowledge of the issues in your case, as opposed to a judge where it's usually picked, we call it the wheel, and cases are just assigned randomly to judges. You may not get a judge that actually practiced in employment law or construction law. You may end up with a judge that was, a prosecutor or a public defender or a divorce lawyer before they became a judge, and not necessarily have experience with what's happening in your case.
That's right. So and they have less time sometimes, certainly in state judges. A lot of cases they may not have as much time to educate themselves. Whereas the arbitration process, there's a little bit more time to brief things, to give, and the arbitrator takes time. And usually, generally, everyone picks someone that reads the briefs before them, and so you do get it feels like a little bit more time with them than you normally would when you're dealing with a busy judge.
Right.
So the cons, though, is I think you and I have talked about this before, is the debate of whether or not, there's really a cost savings to go that way.
Right. And I think arbitration and the arbitrators are getting extremely expensive. You pay them, thousands and thousands of dollars a day. And I don't know whether some cases are actually less expensive to arbitrate than they are to litigate anymore.
I mean, it's not a bad gig being an arbitrator.
It is not a bad gig. It definitely is not a bad gig.
They charge by the hour generally, and if you get a panel, which is 3 of them, it's triple the price. So pay close to those arbitration clauses. If they talk about 3, a panel of 3 is interesting because everyone kind of gets to pick probably their own, and then there's one sort of middle ground person, and you may get a better result. But that's a costly arbitration for sure. 3 panel
right.
Judges.
And so what kind of brought all of this up today is there's a new decision involving Amazon that is really interesting. And the judges in the Ninth Circuit, it's a case out of Seattle, and the judges in the Ninth Circuit had some really interesting comments about why this case falls outside of the arbitration rules.
Yeah, it is an interesting case. So the majority opinion talks about the primary issue that they're addressing is whether AmFlex delivery workers are exempt from the Federal Arbitration Act's it's 9 USC Section 1, the enforcement provisions, because they claim that they're transportation workers engaged in interstate commerce. Now, if you didn't know who AmFlex delivery workers are, maybe you don't live really close to an Amazon warehouse, but they're the last mile, apparently, detailed quite well in this opinion, the last mile drivers. So they actually are part of Amazon. It's a piece of how Amazon workers fall and sort of they take from the warehouse, if they can, and deliver these sort of packages. And they're referenced as sort of the last mile delivery people, but they're not always drivers, Camille, right? I find that very interesting.
That's really interesting. I didn't know that, because obviously in Los Angeles, I only see drivers, in the vans that drop off the packages, and I see them driving around the neighborhood all the time.
Yeah, but in this opinion, they detail what these AmFlex delivery people that in some cities they're delivering by public transportation or by bicycle. They have they're carrying Amazon packages, and then whatever's left over, I guess they bring back to the Amazon warehouse. But so they're an interesting sort of piece of the full delivery of all Amazon, and here there's sort of a fight going on. Amazon, now this is a wage and hour claim, and there's quite a few people in this as the plaintiffs. Many of the plaintiffs were not included in this particular opinion because some of them these legal issues didn't apply. But for one of the actual employees, there was an arbitration agreement that he agreed to when he decided to work as this type of worker for Amazon. And then Amazon wanted to enforce the arbitration clause. And the lower court said, you're not going to be able to do that because he falls under this exemption under this Federal Arbitration Act, which encourages arbitration generally, but allows for an exemption if you're a transportation worker that's engaged in the interstate commerce. And the interesting part about these workers was, and the argument, right, between it's like a 65-page opinion, but the majority's arguing, that this guy is exempt and he is a transportation worker. And then and then our one judge here, who's dissenting quite at almost the exact same length as the majority opinion, another 30 pages, is saying, no, he never really crosses state lines, so he shouldn't be exempted, and Amazon should have gotten their arbitration.
Right. And so the judge, and I'm going to let Trisha tell you because she explains it much better than I, but the dissenting judge actually had an excellent opinion about a coffee grinder.
Yes.
In there.
Yeah.
I loved it, Trisha.
Yeah, it's interesting because he starts to sort of say, well, he feels that the majority opinion was pretty broad here. And the reason why we're talking about this is because if this, does go up to the Supreme Court and becomes law across the US, this could affect quite a lot of different businesses, especially if you do have delivery drivers that are just sort of that you have under arbitration clauses, and they're within, just driving within the state and not crossing state lines, because they didn't really, or at least what the dissent says, is they're talking not about this class of workers and whether or not they cross state lines. It's whether or not the packages that they actually are delivering cross state lines. So they sort of are the end of the distribution. And the dissent, and there's quite a concern he has about that. And he gives this example about the coffee grinder. He says, so, all right, imagine someone orders a coffee grinder through Amazon's website. The coffee grinder is manufactured in China, travels across the Pacific Ocean on a container ship, arrives at the port of Long Beach. A truck driver then hauls it 50 miles north to an Amazon warehouse in the San Fernando Valley. Then an Amflex worker picks it up from the warehouse and delivers it by bicycle to an apartment a few miles away. And the dissent says, would we say that this Amflex worker is engaged in foreign commerce? And he says, I doubt it. But by the reasoning of the majority opinion, the answer must be yes. And I think his example is that it's so broad that they're saying that these workers that are delivering things by bicycle and aren't crossing state lines, are they really going to be exempted from and considered to be part of interstate commerce? Interesting.
Well, the opinion goes a little bit further. And what I thought was interesting, he had a cherry Coke example in his opinion, and that if we order the cherry Coke from Amazon, are these workers going to be exempt? But if you order it from your local pizza delivery and it originates, even though the cherry Coke may have originated from Amazon and been delivered to the pizza place by Amazon, that person who got it from the pizza delivery place, same 2-liter bottle of cherry Coke, but that person may be subject to an arbitration clause, whereas the person who delivered it directly from Amazon may not. And I think that was just an interesting point that was brought up, is where do you draw the line and how far back do you go in that delivery process to draw that line?
Yeah, there are some good examples he had in there. Certainly, points out some issues that the majority may have, and that at this was pretty broad about what they did. And so, as we've talked about this before, Camille, of course, it's following a First Circuit opinion that's also in agreement with it. We're looking across, and there is disagreements about how this is all interpreted. So still to stay tuned and see how it all plays out. But where you fall, Camille, now on the Ninth Circuit.
Well, I do. And, it's interesting because I know last year, California passed a law that actually prohibited employers from requiring employees to sign an arbitration agreement as a condition of employment. And obviously that contradicts the federal law that is pro arbitration. And so that law has not been enforced, despite the fact that arbitration is not highly favored by the California legislature, at least. So it'll be interesting to see what happens with that as well.
Well, arbitration's been a hot topic in the employment law realm anyway. So this is just one more interesting thing on it. I'm sure Amazon's going to fight it. And so, as much as they can, we'll have to see how the rest of this all plays out. But it was a good discussion for us to have here today, and certainly should be on the minds of employers. Also, whether they want to, jump into arbitration, they should think about the cost related to that. I think that's a good point as to, do you want to be in arbitration or do you want to have the shot at a jury trial? Is it really going to be more beneficial? Something, just a lot of factors to think in there, what the claim is, how complicated it is. If it's so complicated, a jury wouldn't understand it. Maybe an arbitrator would make more sense. But, lots of things that go along with that. I'm glad we had this discussion today, Camille.
Thanks, Trisha. Have a great day. And thank you for joining us on 3Bs on the Law. Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.